So as Councillor will recall, we have delegated voting to Councillor Strange as our primary delegate, and Councillor Mahuta has got the secondary in case Angela's not available. So I want to give them a pretty clear steer from this council as to where our position is. So keen for them to be very clear which direction council would like the vote to go on each of these. So we'll just work our way through. All right. So on page 52 of the agenda for the workshop, we've got the first remit, which is in relation to security system payments. Now I'm going to take all of these as read. So would anybody like to express a position? Yep.
So I was just curious, I mean, I've never heard of people doing this before, but it just seems to me that it's got to have a pretty secure parameters around it. Otherwise, people will be using it to get cameras to watch their dogs and all sorts of things, eh? Notwithstanding there are genuine cases where you probably want to do it, but that's the issue with that one. And the trouble with these, all of these, I don't give you enough info to know where they're going with them.
You've got them in your pack. We could maybe bring up just this bit of each of them. So the remit is that LGNZ advocates for security system payments to be included as an allowance under the local government members' determination in line with those afforded to members of parliament. Yes.
Just of the CE, in terms of health and safety for councillors and the real security risk at times, what would you consider to be reasonable measures of an authority like ourselves to help us protect ourselves before we start asking ratepayers to pay for it?
Yeah, it's interesting. I just did a calculation. If it did it in line with the members of parliament, why not be $77,000 for him? I guess, I mean, we would look at whatever the specific risks that each individual might have and assess it on an individual basis and put whatever's necessary in place. I mean, I don't know that having a security system, depending what the risk is, necessarily removes the risk. But I guess that they're looking at it as an opportunity to be a deterrent, I suppose. And if it's good enough for members of parliament, it could be. But you know, we'd have to assess the risk and look at what the appropriate mitigation.
I think it's allowances, just like we do put through our monthly allowances. It includes mileage, phone, computer expenses, those sorts of things. It would be, I suppose, paid for through that allocation. So it would be paid for through our rating base. Yeah, it's not a special. It's not like remuneration that comes from. Oh well, no. Because how did it happen with childcare?
This is a capital cost, though, Madam Chair. This is not it's a reimbursement for capital cost, which is a private expense. I just don't think it's appropriate. It's like there's an ongoing monitoring cost, monthly monitoring cost. Maybe there's an argument in favour of that, but that's $30 a month. It's nothing. Whereas this is, you know, you're talking about serious capital cost. And I just think it's a personal cost. Nothing to do with guns.
I don't know what kind of. I haven't been keeping track. Sorry, I'm not sure. I think Ben was there, and
okay,
then, sorry.
I don't agree with it.
No.
Personal experience of it. One of the female councillors at Waikato District, she had a very, very large, extensive rural ward that contained mainly of rough, unsealed roads. And she had occasion to break down or whatever because of the road, and she asked that she be supplied with a satellite phone. because there was no contact out there, and even the, whatever it's called now, One Network only does texts, and I wouldn't rely on that solely. So the council provided her with a sat phone, which was available to access 24/7. And I think it's on a case-by-case basis and over to council, but health and safety is paramount. And if it's deemed important, then council should address it. But to go this far, I'm not sure. Yeah.
Jen?
Yeah, I'm mindful that obviously councillors and TAs get a lot more focus on with this topic, but I like the bringing things in line between central and local government to some degree. It's just, I do think it might be one of those things where I'd lean more towards it being assessed by the council as a provision, and then when you're finished with your term, that provision would then be, even if it was funded by council, for example, uninstalled and taken back rather than a, yeah.
Angela?
Yeah, sort of agree with Noel's point so far that it's case by case. Yeah, health and safety is important, but each of us has different needs at different times as well. So I'd probably advocate for a more, yeah, I don't really agree with across the board allowance, but, you know, a little bit of security money being available if needed for a satellite phone or something else. If yeah, so I'm not sure how that fits with a remit. But.
So I'm not hearing a lot of support for this.
That's a
If
good
anybody
topic. It's
No, no,
just
it-
is
the detail,
supportive,
devil's in the
No,
detail.
not
of-
supportive, but I think just the remit's wrong, but you could suggest that councils on a case-by-case basis under health and safety might. It depends how you voted that week, whether you're in security.
But this is a black and white,
this
right?
is a
This
yes
is-
or no.
So I'm happy
So
to have further.
I'm not hearing any yeses, so I think we've got a clear stare on that. Yeah? Okay. Yep.
Absolutely assess it. You know, we provide Vodafones, which One New Zealand plans, and they're meant to be having satellite opportunities on the phones anyway in the near future. So, but we'd assess it on the as that example you gave on the risk and whether it's a personal benefit or a council liability. If they're driving all those roads for personal reasons anyway, it's different to if they need to do it for their work.
All right, so we'll go on to number 2. This is on page 54, improving joint management agreements. This is put forward by Northland Regional Council.
Keen to understand it a bit more.
Can I get it, Mike?
It's a bit hard to understand what they're wanting.
Mm.
What do you know, Tipper? Yeah.
So I only know from attending two of the Northland Regional Council things. So JMAs are an instrument of the Local Government Act. They wanted to move into proactive JMAs, but wanted more guidelines for how you do this because there are none. So they would be modelling us, but we've got a treaty settlement that caused us to form a JMA. There's no other handlebars, and this is the handlebars they're asking for. I don't know if they're right or wrong because we've got JMAs.
If it's developing.
And this might
guidelines,
be
that's
moot if JMAs disappear, or if that model disappears under the RMA, then mana whakahono is what stands. I'm not too sure.
fine. I mean, I'm for guidelines, but yeah, I agree with.
They got to convince more of the room than us. We have JMAs.
Yeah, I couldn't see enough detail in the JMA, or sorry, enough detail in the remit to
So why?
understand how it sits in relation to mana whakahono rohi.
Yep.
And in relation to our existing JMAs. So without any of the technical expertise
Be hard to
and
get.
analysis of the specific options, I couldn't feel that I could support it.
Mm.
So anybody making an argument to support this remit?
Well, like I said, issue with clarity, but if it was just to provide a guideline, kind of like we get provided with a guideline for code of conduct templates and things, then I have no issue with it. Guidelines are good considering the diversity of 78 councils,
Yeah.
but I don't know if that's exactly what this is aiming for. But it sounds like it is, so I'd be happy to support a guideline for LGNZ
But
to
I
develop.
don't
but-
think that that's what they're asking for.
Right,
So,
like I said, I wasn't quite clear. Yeah.
They could do that as Northland, eh?
Yeah,
don't
they
take
could.
all of us.
they could. So, so I'm not hearing support for that. No. Okay, we'll move on to number 3, which is the alcohol licensing fees. Now, this doesn't even pertain to regional councils.
Someone who did not use Yeah, as someone who did
the
9 years
licensing.
at issuing the permits for Waikato District, this has not been changed since it came into being in 2012. So I would support the TAs in the remuneration here.
Yeah, same here. I've heard it's an issue.
Yeah, I mean, what you collect isn't covering the costs, so
doesn't.
shortfall is made up by general rates and as a ratepayer, no.
Well,
I
Yeah.
just, my view is we're a regional council. We don't do the alcohol licensing. We're one of 16 out of the 78. So our vote, yes or no, is not going to be the one that I don't think sways this. And I would advocate that we abstain from this
Well,
one.
I would advocate
So-
that we support our TAs.
Are they supportive of this one?
Yes.
Yes, okay.
Have we
Yeah.
checked with all 11 of our TAs in our region?
Well,
Has it been a
you
mirror?
only need to check about 3 people because there's there's about 3 commissioners that do the whole lot. So
I'm with you, Pamela. I think it's not our gig and we should stay out of it.
Yeah. I imagine the
None of these
TAs.
permits are out, though. It's them asking. When you look at the bylaws of alcohol in Hamilton or Waikato, we as a regional council don't have a say anyway.
Mm.
But as a constituent in your district council, you do. So you've got to look at it from that perspective, I think.
Yeah, I agree with Carter, just because it's not in our lane doesn't mean we shouldn't have a view, but if it's just, I don't know, if it's to provide more information to help people, I don't have a problem with it. I'm happy to support.
This is not providing.
This is, yeah. Sorry, what did we think we were debating?
Sorry, I was
We're
half-
debating the alcohol licensing fees.
So look, I'm in support of it, because it's my blooming rates. More money get out of the government, I'm happy. And the more we can put our rates
The
up.
taxes don't go to the licensee, eh?
the licensing fees, you've got the application for a license for a premises, you've got for the manager's certificates, and that fee, it might only be, say, $200 or $300 for a standard application, but if there's community appeals against it, and commissioners, 3 commissioners sitting on, 5-day hearing or 3-day hearing, you're talking thousands of dollars. It does not cover the cost of even maintaining the business, and it's a liability to the local community, local TA. And then I think it was $80 an hour or something for commissioners. It was parallel with the RMA commissioners. It's lost that relativity. So it's a whatever it's called, a Crown something or other, and that hasn't been reviewed since the start of 2012. So it needs to be.
I would just say, I think Noel's speaking with a passion from a district council perspective, and I imagine the district councils will all be equally passionate about it. So I think we're neutral as regional.
Well, I'm speaking as a former commissioner through the absolute experience.
So, okay, so I just want to get a clear direction, and there are 3 ways we can vote here. There's, yes, we support this remit, no, we don't support this remit, or we abstain from the vote. So those who support the remit, can I get a hands up?
Yeah, support it.
1, 2, 3, 4, 5, 6, 7. No. 1 no. and abstain. 1, 2, 3, 4. 4 abstain. All right, so 7 yeses to support. So there you go. There's your direction. All right. 4 is aligning public and school bus services.
Yeah.
Yeah,
have
so
support.
this was discussed at regional sector and was changed from its original form so that it particularly gives the option for a public transport authority to either combine these or approach the MOE to combine.
Yeah, so long as the funding follows.
Exactly, and that was the key.
Otherwise,
Yeah.
no. Funding.
Yeah.
Yep. Put on that basis.
I mean, the risk we've got there is that MOE tends to cut services. Don't
Exactly.
they? Leave people the
Yeah.
minute they need
The
short
moment
funding.
we
Yeah.
hint at providing a bus service for the community, they just
Yeah.
withdraw.
So support, yes, support for this. Anybody against? All right. Yes. Okay, and on to number 5, which is review for local government arrangements to achieve better balance. This was put forward by Tauranga City Council and supported by the metro sector. That LGNZ works with the government and councils to review current local government arrangements, including the functions and structure of local government to achieve a better balance between the need to efficiently and effectively deliver services and infrastructure while enabling democratic local decision-making.
So this sounds
And
like an
actually,
overarching umbrella thing of the previous remit, of which is one issue, the bus thing. I mean, we had the future for local government review. Of course it needs reviewing. Actually, what needs reviewing is central government and local government.
Yeah.
But anyway, there's nothing for me to say this is a bad idea. We all know that stuff needs to change, but it's not specific enough for me to care either way, to be honest.
So,
My view is
Yes.
it doesn't say anything.
That's right.
It's waffle. It's like,
LGNZ's already
working with
advocating for
government
this,
and councils,
so
which is
I-
what the remit is, that LGNZ work with government and councils. So,
Yeah.
uh, but I would support that, that the message is from our councils is that LGNZ, we expect you to play an active role in advocating on
Always.
behalf of the sector around that form should follow function and that the current form doesn't necessarily deliver both on behalf of central government as well as our local communities. So if we're saying that it doesn't really say anything, but it supporting this allows us to,
I see no
Just-
harm in
yeah.
supporting it.
Ben,
oh, I was just going to ask, subsequent to this, is what happened to our resolution to bring the timeframes aligned between census and
That was successful.
it was successful, but has anything happened? Or do we get to ask that at the
yeah,
local
they,
government?
no, they sent, that
Mm.
was distributed, the letter that LGNZ wrote in response to that to.
The letter,
that
but
they-
has the government done anything?
No.
No.
Not that I've heard, yeah.
You're lucky you get it done.
Angela, did you?
Oh,
want
yeah,
to-
I'm just curious. It went to metro sector. Did it go to regional sector as well?
Sorry, what was that?
Metro sector supported it. Did this go through
No, this
regional?
didn't come to regional sector. But I don't see any harm in supporting it and continuing to say that we as a sector need to advocate on behalf of ourselves around how this country best sees democracy serving our local communities while achieving an overall direction as set by central government. Favor, yes, support? Anybody violently against it? All right. All right. Okay, so we'll support that one. Great. We've got good direction on those. So just because I know everybody is keen to move on to the next one and finish up as soon as we can today, we will go on to our next element of this collective workshop, which is the, this is on page 62, the JMA and CMLA reviews. So counselors will recall that we have been reviewing the Waikato Tainui, or the JMA, the Ropatu JMA with Waikato Tainui, and alongside that, the co-managed lands agreement. And we have also been reviewing the Terret JMA. These have been through those co-governance committees. The current drafts have been approved by both of those committees. They have gone through a high-level legal review, which that was distributed to counselors last night. So this is where we are workshopping both of these ahead of next Tuesday's council meeting, where these will be, are they two separate agenda items, or are we going to combine them into the same agenda item? I mean, they could be separate motions within the same agenda item, but.
Okay.
Oh, sorry. Kia ora, Madam Chair, o tērā koutou. Look, I haven't really thought through the detail of next week's meeting, but it does make sense that decisions on the three separate agreements are taken at least at the same time. But whether or not we do it in one resolution or separate decisions on these things, we'll turn our mind to it in due course.
But they are coming to council as an agenda item at next Tuesday's meeting.
Correct.
Right. So this is an opportunity for councillors just to get their heads around the proposal and ask any further points of clarification in terms of the high-level legal review, and indicate any further direction or information that would need to come through in the report and the presentation accompanying this decision next week.
Question, can
Yes.
Marley explain to those who weren't present at the JMA meeting last week what the outcome was insofar as this part, well, it's only one part now, isn't it? Because there was part one and part two, but the original, those who saw the agenda would have seen that there was a suggestion to bring in a wider area into that. And can you explain what happened in a 101 short version as to why we've ended up with only the one?
Here we got to.
Yeah, where we got to, please.
Cool. Thank you for your partai. You're all aware that the review of the JMA with Waikato Tainui included a specific look at extending the geographical scope. At our most recent meeting, co-governance meeting with Waikato Tainui, the decision was taken to remove that aspect from the current review process on the basis that there is more work that needs to be done. It is more complicated than simply what we are proposing in the current review process and where we're landing. So not part of this review process.
Basically, the JMA revised version is for the existing
Area.
Close.
Yeah.
Thank you.
And it was
Correct.
unanimous.
We then look at the 5.2, which was of concern to myself and maybe one or two others there. But there's some comment come back. And I was very concerned about the wording opened, which can of worms. So can we go straight to the parts of that, please?
Yeah, okay, no problem. I might just check in.
Can I just check in with Tippa, just before we get into the nuts and bolts of the legal advice, just any,
Oh, yeah,
did you have higher level or?
yes.
Yeah.
I just want to note
Sweet.
my participation, whatever it is in this debate. Noting that prior to the last workshop, quorum of the councillors felt that they needed legal advice. I've since received the legal advice on my perceived or real conflict of interest. Just would like to note, I'm disappointed that could have been a conversation rather than cost the council money. And I would have been happy to live with a CE's or even Neville's declaration on my conflict. Now we've sent money. And I just think that's a total waste of governance funds for this council. We should have enough relationship where someone could have asked me around the table, I would have gone and got the advice, brought it back, and we could have all had the consideration. But if we're going to be hoodwhackers, kino mai te a. So I've received the advice and I understand it. Well, I don't endorse it because it would make quite a few of my participations in council problematic. And it also problematises everything else you guys all belong to. Every farm gate group, every catchment committee, all of those decisions I must vet now into your interests in those matters. And I trust you enough to know that you're not exercising that, you're acting as good community members, that you don't trust me in that way. I'll take that on board, but hey, nā koutou tērā e hara nōku. So in understanding the advice, Marley, it says that I should not, for the purposes of the changes, participate in the deliberations. Doesn't extend to the whole JMA or anything around that because of my role as the chair of Whakakitenga, not just as my role as a tribal. So I recognise that I have a delegation that sits outside of this chamber, that this chamber, 1, doesn't understand, 2, doesn't need to seek legal advice because we're in partnership, and 3, has its resources without buying legal advice. That is the point of contention I have, is that we actually spend ratepayers' money on common sense kōrero. And we did a lot of that last term, and I don't want to end this term kawa like this at people that I considered colleagues, even if we hold this different views about it. So what I'll say to my colleagues is, I think between me and Kata, we're the only people here when these JMAs were forged. Maybe. I think, Chris, you were here in a different role. Marley was here in a different role, but pretty much, and you might have been here as a councillor. So we're the only ones with the histories on that. You deserve what we understand about this, but I'm happy to not take part in the decision when it's made in council. I consider for the purposes of this, my colleagues should let me participate in the workshops and the discussions. You fellas have the votes, but you've got the votes anyway. Amy and Kata, 2 or 14, what is it you're really scared of, that the debate is had in council? What is it you're trying to not have Tippa say next week in the deliberations? I'd really like to understand that, but I'm not going to be sad about it. I just think we wasted ratepayers' time and energy. So I'd like to seek leave from the room. Can I participate today or not? If it's not, then I can leave and go and do other great work for my iwi or for this council. Up to me, really, because I carry both delegations. Kia ora.
I would like you to participate in this conversation today. I value your input as I valued your input around the JMA table when we were discussing this last week. You know, a declaration of interest or a conflict of interest can only be declared by the councillor themselves. And we all have declared the various organizations and interests that we have in our.
So could I just
interest
note, in case other members who weren't on the JMA don't understand, nominated to the JMA committee as councillor, I do not hold the appointed JMA role for Waikato Tainui. That's a separate process that the tribe goes through, for which Jackie Collier is the chair of that. I have no authority over Jackie as she represents the tribe in the JMA or that committee. But I understand that would take a whole probably thesis to write for the Tainui tribal structure that we don't have time for. But I'm very clear that I don't speak for Waikato when I'm in the room. Do I understand the politics of Waikato? Yes, I'm a tribal member. But I do not have the tribal authority to speak for them in the JMA. Kia ora.
Can I ask a question, please?
Yep.
I haven't seen the ruling or whatever that Tippa's talking, or the advice. I accept what she's saying. But I'm just playing devil's advocate perhaps a little bit here. Does that also affect Katarina?
I just
And therefore, how far does it extend? Because Robbie and I are farm owners and we go into the catchment. And Bruce is very tied up in biodiversity and biosecurity. Does he stop being part of, where does it stop? And I'm not saying you're out, but is when are we out? Because there comes a line, and I know very well that I'm here to represent the interests of the ratepayers. If I start promoting my own interests, well, then I need to be given the kick.
Yeah.
So this is a very important part in our way forward here. So it's over to others to make that decision, but to isolate someone or people from the table when they've got knowledgeable information that we could understand and make use of in our decision making, I would be disappointed if that was to happen. And I'll leave it there. Thank you.
So I haven't seen the advice that's come through. And from my point of view, like I said, it is for a councillor to determine whether or not they are conflicted. And we have always been aware of the position you hold, huh? As all of our declarations are on the register. So we all know the various positions that we hold. And Molly, would you like to?
Can I just say something?
Sorry. Okay. Councillor Ryan.
Thank you, Noel. It's a good conversation. So when it comes to JMAs and all the this is the first term I have ever not sat on a JMA committee for the council. I have always sat on JMAs for the council. I have never tautoko te iwi. This year, because I was the chair of Raukawa, I decided to have a conflict of interest within the JMA, so I don't sit on them. But, I didn't have a problem, in order to our councillors back then, that I sat for the council against my iwi. Nobody ever asked me, don't you think that's wrong? But in saying that, I actually belong to Tawat. I whakapapa te Tawat. And I'm the alternate. But nobody questioned me being the alternate for Tawat. So I'm lost in this. I at the moment, I'm the alternate for Raukawa because I'm the chair. So if Raukawa doesn't have enough people to come to the JMA with you guys, with WRC, I come as the Raukawa chair. And there's no way I talk about the council. So all I'm trying to say is Tipper and I, over the 12 years we've been with the council, understand what hats we wear at what time. It's something that I'm sure a lot of you do anyway. You don't go to a meeting for something and wear something other hat. And it saddens me that all of a sudden this is a conflict of interest. But I listened to Neville talking to Tipper in the lunchroom today around it. It just opened a whole lot of room of cans, Pamela. But I'm not on JMAs for the council this term. I decided not to. But it saddens us that we bring a lot of information that affects the council when it comes from the council to iwi. We have a lot of input, a lot of information, and by us saying we are conflicted, which is no different to what Noel said, I think the council is losing a really important part of mine and Tipper's non-inclusive in our JMAs, because we help write those JMAs. I was there when the treaty claims were done with Okawa. Tipper was there when the treaty claims were done with Waikato Tainui. We have a lot to offer, but I'm not fussed whether I'm in it or not. Hence why I chose not to be in the JMA. And on occasions, I'm asked by council and our chair to represent the council from an iwi perspective. So, I'm lost in how and where I sit. But hey, I'm all good.
So again, I'm just going to say that a conflict can only be declared by the individual councillor.
I just would hate for it to prevent the council
Yes.
from making a decision
Yeah.
because people have seen the process, cause a process problem for next week's decisions.
Yeah.
So again, err to the side of caution, participate in the discussion only, allow for the vote to happen without me. I'll notify Waikato Tainui that that's the case because they might think I'm in there because that's what was represented last week. Again, just because they're my constituent iwi. And I'm happy with that. It's just whether I'm going to get another letter
requesting more advice or costing this council more money. So happy to make that advice available so that it doesn't cost more to the ratepayer, because I think it's a waste of time.
Oh, I'd like to comment. Simply say that from what I understand from what Tipper has just said, is that if she was there as a tribal member, there'd be no problem. But that the legal advice, which none of us has seen, suggests that by being chair Parliament, simply when a JMA, which is a legal document set under treaty, which requires a minister's sign off to change, that's the only area where she should not be sitting in both seats.
Doesn't,
I,
it doesn't
like I
require
said, I
ministerial.
haven't seen this advice, so I don't know what the advice.
Sorry, JMAs are out. We make the decision here. It doesn't require ministerial change. It required a
Yeah.
treaty settlement to make us have a JMA.
In
We
the,
police our JMA.
in the earlier documents, the ones that were in closed session, it did say that the minister would be advised of the changes to the
Yes,
JMA.
advice.
Notified. So what I'm saying is it's a kind of statutory document, which is different than just ordinary run of the mill discussion. So I'm perfectly happy with being in workshops and things like that. I think when it comes to changing a JMA, it probably should be that criteria.
Molly,
Don't
can
think
I
it-
get you
don't think it
to,
applies to.
can I get you to
council
come in
boards and-
here, Molly?
Thank you for the opportunity to respond to a few things that I've heard. First of all, we've only just received the legal advice last night, and as a matter of courtesy, made the decision to first have the kōrero with Councillor Mahuta before then circulating the legal advice more broadly. That's why you haven't seen it yet. We've only just had the chance to discuss it with Councillor Mahuta. The advice talks about this specific decision, which is related to amendments within 2 statutory agreements, where the council and Waikato Tainui are party to that. It does not implicate Councillor Mahuta's participation more broadly in discussions related or falling out of our co-governance with Waikato Tainui. So just this one specific decision. On the point about how it might affect Councillor Hodge, it doesn't, because our discussion today and next week isn't with Raukawa, and our agreement with Raukawa, it is Waikato Tainui and Te Aroa River Iwi Trust. Whilst Kataraina might have whakapapa connections, she does not hold a position within those trusts that we have these agreements with. So Kataraina isn't affected by the principles that are falling out of this legal opinion. For council, not for Te Aroa River Iwi Trust or Waikato.
Can I just note that while I've received the legal advice, it doesn't contemplate the Waikato Tainui group structure, and I would not be the signing chair of this matter. It would be Te Kuruerangi Morgan. So we have delegations in our group. If we go just off this, you can't talk about Tainui group holdings when I'm in the room. You can't talk about our extensive group of entities when I'm in the room, because I chair the group, not this part of the organisation. That's Te Kuruerangi Morgan. Again, that's a layer of information none of you have or would have. But I'm happy for that to stand. But I just worry for the future, because otherwise every iwi member that sits here is going to be excluded at the convenience of council. Kia ora.
And I suppose that I think about the other implications of anybody who might have a farm and might have a water take, and any implications in terms of establishment of freshwater policy around this table. What does that then mean for any farmers who sit around this table?
It is a valid point and matter that council must turn its mind to at the appropriate time when decision making is happening. We are going through the process of seeking exemptions for councillors related to freshwater policy. It's not guaranteed. We do have to go through the process of identifying what the interests are, and also the detail of decisions that are coming down the pipeline in order for the Office of the Auditor General to consider the implications clearly and provide a decision. Yep.
Four. 1, 2, 3, 4. Stu? Oh, sorry. What are you talking about? Oh, WIOTA committee. Sorry. Hmm. Hmm.
No, I'm in the wrong catchment, sorry.
Sorry, I've got Jen, Bruce, Warren, Chris, and Noel. I do want to move on to the matter that is before the workshop today in terms of the content. So I want to, if the speakers want to speak to this, can we be quite concise and move forward? Jen?
It would be useful to see the legal opinion before we all.
And Molly has said that that has only just been received, so it will be distributed, I assume. So I've got Jen, Bruce, Warren, Chris, Noel. Jen?
Yeah, it's a good guide by the Office of the Auditor General, and it talks a lot about personal enrichment, which is not something that's that relevant. But I am very keen for everyone that is elected to participate as fully as possible, and then obviously they make their choice. And just as an etiquette thing, I would like that if somebody has an issue with anyone on the council, to raise it with that person first, and then do a conflict resolution if you can't agree through Chris and whoever else to get to that point. As Tippa said, we don't want to spend money on this and we don't have to.
Bruce?
Yeah, very quickly. Yeah, I want to see the ruling, obviously. And just recognition of the two components of this. We all have a general register of interests. That's one thing. But in any particular meeting, there could be quite specific reasons that people need to withdraw on. And Noel raised a point before, I wouldn't be withdrawing because I'm not in the catchment relevant. But it's entirely context dependent. It's about whether you own property or whether you're going to get some financial gain or whatever it might be. But it's often a very specific reason you would have to excuse yourself from the discussion. So, but a general register of interests normally is enough to do it for nearly every meeting of the year.
I think about, Robbie, when you chose to withdraw from when we were discussing the leases. Yeah, grazing leases. So that as an example of what you're talking about.
I didn't even have a grazing lease, just my family had one, so I removed myself.
Yeah. Warren?
Yeah, so just as a reply as the author of that email that did go out, all I did was raise the perception that there may be a perception of a conflict of interest. It obviously was sent to the chair, and I think it could have been addressed in quite simple terms. I didn't ask for legal advice, anything like that. I didn't contact Tipper by phone, no, but the email was circulated. Perception can take many forms. You know, I've been asked if I have conflicts of interest in various things, most recently the coastal plan. You address it, answer it. You can either say, yes, I can approach this with an open mind and prepare to have my mind changed, or no, I do have a conflict potentially that whether it's monetary, whether it's relatives, whatever. So it was just raising the question, and I'm sorry you've taken offence that it was through an email and the fact that it could have been, yeah, but it was over a very short period of time that we were trying to get some things together. So I'll just leave it there. But
Sure.
To me, it was a perception issue.
Chris?
So it is public perception, and I think everybody understands what that means, and that's why, to me, it's important. Having come from a professional environment, we understand the conflicts of interest, and I could bore you with details of some of the major decisions that have to be made at that level. But it's public perception which has to be satisfied, not personal perceptions.
All right, Noel, did you want to say anything else or just microphone? Microphone.
Didn't until a moment ago, but I note, having received a copy of that email that you sent, I was mentioned in that without my knowledge, and that's not a bad thing, but just the fact that I was mentioned as a proposed alternative to tipper would have been nice to have been advised that that was being recommended. I know I'm the alternate, and had tipper chosen to withdraw, I would have been asked to step forward, but I just think if you're talking about people, it would be nice to know that you've been talked about in whatever context. And it's not a criticism, it's just a request, perhaps. Thanks.
All right, so can we move on to the draft JMAs and or revised, reviewed JMAs and the CMLA?
I might just check for a bit of direction. I have prepared some information that will take us through legislative context, the process that we've followed, and also the key amendments within each of the documents. But if council feels like they've heard this over and over, because I have spoken about it a number of times, then I'm happy to fast forward through to maybe the last part, which is the key amendments and the legal advice. But just seeking direction, would you like me to cover the and provide a recap?
The beginning and have it reviewed. Or we move to the key points, the key changes, and the high-level legal review that has been. Which is it? What's the direction? Key
Oh,
points and
okay.
legal. Is everybody okay with that? Yeah.
Sure.
Yeah.
Thank you. We'll
Great.
skip then to around the fifth slide, please, Jordan. This is the one. So just recapping then, perhaps for any members of the public who might be looking at this either now or sometime in the future, we sought legal advice on the recommended amendments to all three of the documents. And we received last night preliminary high-level advice, and we're expecting to receive detailed advice early next week. And so the general observation that has been made by the legal advice acknowledges that the amendments sought are showing a strong intent to uphold enduring partnerships and are grounded in respect and shared purpose. A few clauses, though, would benefit from clearer drafting to avoid ambiguity and to ensure compliance with other legislation. Skipping ahead to the proposed amendments in the Tarrant JMA. Next slide, thank you, Jordan. Key highlights include stronger partnership principles, expanded engagement scope, which reflects that we're often taking kaupapa that are outside of the JMA to the co-governance table as an opportunity to meet obligations to consult. So just noting here, it's a really useful forum for council in that respect. Updating the meeting frequency. Currently, we're only meeting or required to meet once a year, and governors and staff are keen to increase this to a minimum of twice per year. We're looking to lock in a commitment to annual site visits to deepen shared understanding on the working relationship that we have with Te Arawa River Iwi Trust. In practice, we've found that the site visits are really useful. Revisiting the review cycle to amend it to 3 years. Currently, with Te Arawa River Iwi Trust, the review cycle is every 2 years, and we're really struggling to meet that review cycle. And the 3-year suggestion is better aligned with a council term. clarifying monitoring clauses, and also locking in a commitment to do strategic work programming. Next slide lands us on the preliminary legal advice received for the Tarrant JMA. It acknowledges that the amendments support values-based relationship that goes beyond just the treaty settlements. It acknowledges there's merit in embedding cultural values like whakawhanaungatanga, and so this doesn't currently appear in the revised JMA, so something that Tompkins and Wake are giving some thought to. It suggests that principles like integrity or honour are also balanced with enforceability under other pieces of legislation like the Local Government Act. And it notes that given the likelihood of future legislative change, te tiriti principles are embedded into the JMA to ensure that there is, I guess, partnership, active protection and participation locked in to future-proof the agreement going forward.
So can I just get some clarification though? These suggestions, so this is on top of what both parties have already agreed to. So can I ask why, is that a yes?
It is,
Yeah.
yes.
So why at this late stage are the lawyers suggesting we add new things when this has been workshopped, agreed between the parties? I would have thought that the legal review was, do the words align with current legislation and not lock us into something that is at odds with that? Why are they suggesting additions that were not requested?
Yeah, it is a good question. The instruction given was to review the amendments and to identify any risks associated with the proposed changes, as opposed to identify any additional clauses that might improve the content of the revised JMAs.
So why did they then add additions to it?
Yeah, some of the advice provided is certainly around the risk mitigation, so referring to other legislation or balancing the changes with other legislation or legislative requirements like those, like the Local Government Act, for example. But I agree, some of the other suggestions that have been made are more than what has been asked. And we can certainly give this feedback to Tompkins and Wake, who have undertaken the work for us. I guess what they've seen is a bit of a gap that we haven't seen ourselves, particularly if you consider that conversations that we're having with Waikato Tainui, for example, have highlighted that we are currently working in an environment where there is legislative change coming down the pipeline, and how are we going to ensure that our work that we commit to under the joint management agreement is future-proof to step us through that change as it comes. So what is coming back is highlighting that there is a gap, and it's up to council and it's up to our iwi partners to decide how they take on board the advice that has been given.
So, but this is advice to us. I suppose that from my perspective, we've been through quite a long process to get to this. And I would have liked the legal advice to have been quite focused on a legal review of what is been proposed and agreed to by both parties, as opposed to adding additional things for consideration at this late stage, my view.
Mhm.
I've got Ben, and then I've got, who else do I have? Ben and then Stu, okay? Ben.
Yeah, I'd like to reinforce what Pamela's just said there. I don't think legal opinions should be coming in and providing new additional issues. particularly as they've done a fantastic job when it came to the clause that was concerned about 5.2. So 5.2 is on page 68.
That's for the ROPOP to
The ROPOP,
JMA,
and it
which we're
basically
talking about
said,
Tara right now.
Yeah.
the
but-
parties commit to upholding the principles of the agreement to the fullest extent possible, including in the face of legislative changes. Now, the concern Noel had raised, and we've also had concerns about, is that this seemed to bind the councils to oppose government policy and was overtly political. And they've gone through and amended it quite successfully, I think, to clarify that neither this clause limits or fetters statutory responsibilities, decision-making powers under Local Government Act. So it clarifies that the idea that you're trying to bind the council, even as legislative framework evolves, they've moved away from that. And yet over the page with Tara, they're going, given the possibility of future legislative reform, we're going to add in all these new clauses. It's nonsensical, and it shouldn't be there, and they certainly shouldn't be embedding principles which aren't defined at this late stage, you know, when we're due to vote on this in less than a week's time.
It is entirely up to council to decide what they do with the advice. When we do come back to council, we will be looking for a decision. We can certainly make sure that that specific additional clause that is being proposed by the legal advisors is clearly either supported or not. I would say that, and I did make the point earlier, that Tompkins and Wake have clearly identified that there is a gap in the Tarrant JMA as it's currently drafted, and the gap has probably been highlighted for Tompkins Wake because they're also looking at the JMA as it's revised with Waikato Tainui. The specific clause that you've referred to, and we will get to it and have a detailed conversation about it, 5.2 in the Waikato Tainui JMA is quite prescribed. It is specifically about changing legislation. The recommendation for Tarrant from the legal advisors is less than prescribed. It's the opposite. It's more descriptive, but it is trying to fill the gap that they see is currently in the document.
Which to me appears to be getting ahead of changes to the RMA, which seems to have motivated. I mean, I just think that the legal people should be told, don't carry on with writing your opinion on that specific issue. It wasn't for a review of what was brought forward over a 2-year review period. We get to the end and then suddenly it won't even go back to Tarrant before it comes for a decision to us. It shouldn't be there. They shouldn't write this in their opinion.
Yeah, we don't have to accept it.
Yeah, just to add, we certainly have the opportunity to go back to our legal advisors on the advice that is being supplied. They're certainly open to receiving more feedback off today's discussion. So I'm quite keen for this discussion to happen here so I can go back and provide some further clarity about what it is that we need in the detailed advice that we will receive on Monday next week.
Stu, Bruce, and then Tippa. Stu.
I'm not upset at all about the lawyers telling us, or giving us advice following a final review. I mean, if we hadn't got a preliminary review, we'd probably, some people might be unhappy as well. But to my mind, I mean, the one that's up there now, ensure enforceability aligns with our legal duties. Why would you not want them to pick that particular one up as an example, you know? But I just want to check in, Marley, is if we approve this next week, are you able to have some dialogue with Tarrant prior to that? Make sure they're all on pages so we don't have to do too much backwards and forwards.
Yes, the intention is to have discussions with both Waikato Tainui and Te Aroa River Iwi Trust as we go through these last stages to make sure that we are as aligned as we possibly can be, because essentially we've got to get to the point where the respective organisations are approving a document, so we've got to be aligned.
Look, just in summary, my view is these last minute tweaks are inevitable when you're doing these processes. It's just life, you know, so I don't think we should be scared of them. And as has been said, if they're not material, we don't have to change anything, you know.
Yeah, I'm prepared to wait to see the full legal report. I think it's important that we see that before we jump to conclusions. But having said that, I don't think we should be afraid of advice coming from legal experts. And if they have identified a gap, and my sense of the gap that's been identified is simply a more, how could I say, a better aligned description of our treaty obligations and responsibilities. And the reason for making sure a gap like that is absolutely clear is well outlined in the Auditor General's report on mitigations and liabilities required by all government agencies in that matter. They've alerted us to potential consequences, Ben. So I think you don't close the discussion down. Let's see the full piece of advice and then make an informed judgment about what we think is what we can run with.
Super.
I think it's positive to just say none of these are yesterday agreements. They're all got 10 years on them. So if we're not past day one, I'd be really worried. And it's sad because whakawhanaungatanga is a day one value. We're either in a relationship to get some stuff done or we're not. So that at year 10, they're asking for whanaungatanga. That's a bit more of a worry if that is real. I'm not too worried though, because we bring it to the table whether council's on that mood or not. I mean, we do. We bring that as their natural course up to the particular quorum of councillors, whether they will engage in whakawhanaungatanga. Point 2, until someone else gets rid of the treaty, it still stands as a baseline to all things. So it's restating it. And item 3 is we're always legally responsible. So I think they were all just to give more clarity, not more rights, to things that should be just a given 10 years in. So if anything, that's just telling to me that we're still at check-in. These still aren't mature agreements. And it's quite sad because most of the originators, Bākata and a few others, even at our council, aren't here to tell us where they expected it to be. Kia ora.
If there are no more comments on, you still got comments?
Oh, not on that one. This one.
Microphone.
Oh, I just thought I did. I'm disappointed that they've had to raise these because the Supreme Court's defined the treaty as being involved in everything, particularly in this type of issue. And so we've got no alternative, but it should be just business as usual, and the need to restate it, I'm a bit disappointed and if not worried. Councils can't act illegally, not deliberately. I don't fully understand. I tried to, I've got some idea what that means because I asked Tipper. But I'm just disappointed that there's a request that it's there, some of this stuff, because it should be business as usual. I'll just make that point.
Ben,
And the Supreme
oh,
Court
sorry.
said we should.
You said you
Oh, just other issues.
on the next one.
Yeah.
Go ahead, Molly.
So perhaps we jump then to the next slide if we're now going to move into other matters. Starting with, well, the next agreement that we're looking at here is the joint management agreement with Waikato Tainui, and the key amendments coming out of the review process include incorporating kingitanga principles and joint objectives, clarifying operational principles, enhancing or committing to strategic work programming, shifting to a 3-year review cycle and also updating some clauses that affect operational mahi and planning, consenting, monitoring functions, all designed to improve clarity and alignment. Moving ahead to the next slide, let's take a look at the legal advice. We asked Tompkins Wake to focus in on clause 5.2, and they have suggested that the current drafting is ambiguous and potentially does create risks to council around overcommitting beyond our statutory mandate. And so they have identified a revised clause that will clarify not just the strong commitment to partnership, because that was the intent of this draft clause, but it also balances council's legal obligations under other laws, and so ensures that there is no ambiguity related to our legal obligations. So it does seek to strike the balance between what we're trying to achieve here, and that is reinforcing the partnership, but doing so within legal boundaries.
Ben and then Noel.
Just a couple of questions. So moving from 5 years to 3 years, does that mean that at the end of every triennium, we're going to be going through the same review process?
Not necessarily the same review process.
At the end, at this time frame, 3 years from now,
Yes.
is that a good sequence? I mean, it seems problematical that you're at the end of a triennium.
Yeah, there's a number of good reasons why 3 years was suggested through the review process for both of the joint management agreements and the co-managed lands agreement. One, and probably the one that was emphasised the most, is that it aligns with a council cycle. So every 3 years we get a new set of councillors around the table. It's an opportunity for each council to take a look at our agreements and identify whether there are any areas that require improvement. The other thing that it enables is better alignment to other planning processes that occur on that yearly cycle, like the long-term planning and also setting your strategic direction. The other thing that is worth pointing out here is that whilst in the Waikato Tainui example, it is more frequent, if you are reviewing more frequently, then the likelihood that you have to take a deep dive is reduced. So we haven't undertaken a review since 2017. That was more than 8 years ago, or 8 years ago. And so the review process for us this time round, it has been comprehensive. If you take a look every 3 years, you're not likely to have to run a process that takes a whole 12. It could be a light touch more often.
So would this be at the beginning of a triennium with the new council, not at the end as we are at this one?
In the middle? Look, I haven't thought about where in the cycle would be the best to do it. Of course, if you're doing it with a new council, they won't have, unless members are re-elected, of course, there will be new councillors that won't have much insight at all into the practical operation of these agreements. And so there might be the need to actually time it so that there is the opportunity for the new council to get their heads around how do we operate in that space before we then open it up and say, right, we can make some improvements in these places.
Well, that's why I was just asking about the 3 years, because we've got the other JMAs that are also going to come up for review. So we're going to have a cycle of possibly 5 all on a 3-year cycle, continuous, arriving just at the end of a triennium, which is not a good look, not a good position. So just something to think about there. Other issues, page 70, schedule 3, it talks about actively seeking opportunities for co-decision making as part of the joint working party's role. And I just wondered what kind of decisions would be delegated to the joint working party.
I haven't got it at my fingertips, but I do know the clause that you're talking about. It's not limited. It could be anything. but it is at the discretion of council and Waikato Tainui.
Okay, because
So-
joint working party is not council laws, it's not governance, is it?
No.
It's
The working
it's
group.
operational.
Operational. And so it might be that there is a significant project that would really benefit jointly working together. And so council and Waikato Tainui might decide to delegate to that staff working group some responsibilities to progress this piece of work, whatever it might be. So there is no limitation to what that might be, but it is at the discretion of council and Waikato Tainui.
Page 71, item 11.2, there's a whole lot of green, which is what is existing, and then there's the red. And I notice in the green, this is talking about resource consent processes. And in the red, the idea that if the iwi haven't come back within a certain time frame, the consent moves forward, now seems to have disappeared. I just want to understand what's happened. So,
Source consent should be held up because you're waiting for some.
well, it says here, and the current green, if no advice is received by day 2 of the consent process in relation to a particular application, the rogue officer will assume Waikato Tainui has no further interest in that application. That's now gone completely.
A couple of things. One, changes to this particular clause were initiated by Waikato Regional Council staff. 2, all of the obligations have been agreed to and supported by Waikato Regional Council staff. And 3, even though those words have been removed, the Resource Management Act requires us to process applications within a particular timeframe, and so that will still happen. Yep.
Page 72 in the red. Discuss potential for persons nominated by Waikato Tainui to participate in enforcement actions under the JMA. So, and I see that's also in the Tarrant one as too. So what does that mean in terms of enforcement? What does that mean legally for the council? And will there be a reduction in council staff if we are taking over enforcement action?
I think that's the potential that this would explore. So we would, as part of
Page
as part of
72.
discussing the potential, all of those matters would come up in the
Well,
advice.
Item 4 in the red.
It would come up in the advice.
Yeah, the RMA provides that it can happen. Doesn't mean to say that it will happen. It's reflecting legislation because
Fine.
the RMA says that you can delegate this. Doesn't mean to say that you have to.
Yeah, this is just
Yeah,
committing
that's
to
right.
discuss it.
Right.
And
Can I get a microphone on?
Yep.
For you to,
The only place where we've exercised the delegation is such as Taupo, and it was monitoring. Te Whare Toa has monitored the lake
Yes.
for us. That's
Yes.
the closest we've done to
Yes.
something like that.
Yes. But the Tarrant one is also bringing in the enforcement one. And then page 72, item 13, successive councils will give meaningful consideration to Waikato Tainui representation across all relevant committees and governance structures. So is that the attachment liaison? Will it be strategy and policy? I'm just wondering what the intent of that.
where are you again?
Yeah.
Sorry.
same
Page 72, item
72.
13 in the red.
So a couple of things, if I may, I'll just go back to your first question about the environmental monitoring and just to add to what's already been talked about with regard to discuss, not committing us to anything. The other key point to make is that in all of the amendments that are being proposed will not result in additional resourcing required from council. Because your question, part of your question was around that, are we going to require more resourcing? And just wanted to reassure council that none of the amendments that are being proposed will result in any additional resourcing requirements.
Because all
we-
we're doing is committing to discuss it,
It's a chat. Yeah.
to explore it.
Yeah.
We're not committing to actually do it
Doing it.
because we can't make that commitment through this process. We need to understand on a case-by-case basis, what does it mean?
Sure. And so if any decision was made in the future to commit to this and require more resourcing, it would have to come back to council anyway to commit to that. Consideration of the Waikato Tainui representation across committees. This was really related to committees that are of specific interest and relevance to Waikato Tainui, like the zone committees, drainage committees. So committees that are established specifically within the rohe of Waikato Tainui. So it
Not just the
certainly,
Environment Policy Committee or.
not those that are of regional sort of general application across Waikato region.
And
And
obviously-
again, it's consideration. So we consider.
Yeah, and yeah,
long-term plan, this is obviously when you get to funding. Parties may work together to develop joint recommendations or work priorities and potential funding allocations to be considered for the LTP. So I guess that's if there is monitoring or enforcement, you'll provide a business case for that. Does council work with other bodies on joint funding allocations for the LTP?
We do that with like CDM, don't we? Or future proof?
There would be examples, and I can think of other councils around the country who have quite formal arrangements in place. For example, not in this, just with one iwi out of a number, but Greater Wellington, for example, has a joint policy-making committee, to make plans. And in terms of your funding question, yeah, we often have to go into some sort of funding arrangement with another party and try and line them all up at the same time, to be able to do something together. NZTA is a classic example of that on a regular basis. And I think that this is just keeping open the door for opportunities to think outside the square of how we currently do all our business. There's no commitment to have to. It's just in the spirit of having, talking about some type of co-governance, how we might do it in the future.
Yep, that's fine. And then the last one is amend the JMA. So this was the idea of amending the JMA to include a wider area of interest. I notice that's not there now. So presumably that won't come up again for another 3 years when the review comes through again.
I am sure it will come to the table again at some stage in the future. I don't know when that will be.
It's a review process, so presumably it's another 3 years. Because it's a 3-year cycle now.
It is a
Right.
3-year
Just a bit of
cycle,
information.
that's right, but there's nothing preventing council and the tribe from reviewing at an earlier date if it's agreed.
But did you want to?
I
speak
just
up?
wanted to give a little bit of a scenario that might help Ben. So if you look at the JMA partners we currently have, who are actively involved in the West Coast Harbours claim, should they be settled, would we want a separate JMA or would we want them to be able to just broaden this one, for example? So that's kind of, I'm just saying the shifting ground isn't Marley's choice. But say Waikato settled Raglan, do you want a separate Raglan JMA or do you want them just to be in the Waikato one? Yeah. So that's kind of, it's not going to grow outside of the tribe's interest area. They can't go and claim Wellington.
Right.
But if it's an active, it's a bit like we haven't defined tauraki yet, but it will come. And once it's in their legislation, we can interact with them that way. Yeah.
Could I just give another example of that? If for instance, one of our iwi partners decided to use a mana whakahono, a rohi option, and that was entered into, we ourselves might be pushing for maybe we'd quite like it to be incorporated because it'll be a lot more simple and efficient process to do it. At a later time. So but I don't know that I'd want to have to wait for some 3-year or 5-year period, whatever it is, before you could consider sort of bringing them together.
Okay, just clarifying that. So those are the questions I had. Thank you.
Great. Thanks, Ben. Noel?
So can we look at 5.2? So we've got in front of us, well, I've got it here in front of me. It says page 91 of the agenda, page 30 of the particular report. And I was absolutely concerned and raised it at the JMA meeting when I was invited to speak because I was there as the alternate. What's up there now is proposed to alter parties commit to upholding the agreement spirit while acknowledging evolving legal frameworks. That is so much better than what was in the proposal. And it's no criticism of staff or iwi for bringing that wording to us, but the reality is that bound us to possibly acting ultra vires contrary to law, because law is a shifting beast and evolves over time, as should the agreement, and that's why there's reviews. So I'm having raised my concerns about this, and no doubt we will have to go back to Waikato Tainui and say here's a suggested alternative, and one that hopefully we favour, because I think it's better reflective of what the legal obligations are. And it doesn't take away anything, I think, from what the intent was, unless I'm misreading this. It's the wording choice was not conducive to legal compliance. So anyway, I'm happy, unless there's further discussion, that the proposed wording
one
is much better because it acknowledges changing or legislation over time.
The proposed that's come through from the
Yeah,
high
it's up
level
behind you.
legal.
It's behind you.
That's what
No,
was in the,
No, that's
no,
what the
that's
change is.
that's the new one. The proposed the one was parties commit to upholding the principles of this agreement to the fullest extent possible, comma, I would have preferred a full stop, including in the face of legislative changes. This commitment ensures the enduring intent and integrity of the agreement, even as the legislative framework evolves. So to me, that the wording of that proposed statement was ultra vires, because you cannot continue to do something if it's become changed by
yeah,
law.
I got that. I'm just trying to zero in on, because this legal advice has a proposed.
Yep.
Yeah, and that's,
It's the one that will come through in the detailed advice next Monday. What's on
Right.
what's up on this on the
right.
screen
So,
is
so
a
this is
summary.
not,
Just summarize.
That's a
it.
this
summary of
is,
it.
Here it is
Okay.
here.
Yep.
So,
yeah, I just wanted to make
So
sure that we
what
were
I fixed-
looking at the same thing. And that if you were endorsing a 5.2, I wanted to make sure we were looking at the same
yeah.
5.2.
I'm happy to wait for the final draft to come through,
Okay,
because this is unbelievably wordy.
okay,
That's simple.
No, that's fine.
Yeah, but the
covers
real, let's wait till
all right, all right. I
Yeah.
think we got it.
$500 per week.
Okay,
Tell us.
Jen,
Oh, good, but I really, really like the 3-yearly review, and just note that it might well fit our partners as well, because they're on a cycle, which is not the same as our cycle, but it does seem from memory to be 3-yearly as well. So it just gives both sides an opportunity.
Reset.
Yeah, I really like that. And I remember in the discussion in the workshop that the idea was that you raise it with us, the option to review. We may well, just like another year, just say, not right now, thanks.
all right. Ben, did you have something else?
Oh, sorry.
No. All right. Is there anything else? Oh, Tippa.
No, I just wanted to, it's not so much about the documents, but if we were to say who has optimised their co-governance, co-management at the moment, I would urge to think that it is, I don't think any of the other TAs are doing any better or worse than us, but I would say if the River Authority is the model of that, what is it they're doing well? Because they're the same partner in the room. And if we're going to help improve the conditions, because they're our other big partner in the river work anyway, how do we make the review cover all of us? Do you know what I mean? Because we're in partnership in the River Authority, and then we break out into these relationships and we're starting to vet the legal arrangements. It's all inconsistent, because the partner on the other side of the table is still iwi. But we change our mind about them when we're not co-funders, when they're just authorities in our region. So I'm just interested in, is it because the River Authority has a consensus-driven decision-making format where we don't require that of the JMAs?
Well,
Because if it was by consensus, then it would be reasonable on both sides of the table. It's what can the community get to, rather than the democratic right and will of some over the others, as some people are worried about here. I'm just saying, if we're going to play a strength-based game for the future, what is that? And I'm just flagging it. I don't think we need reviews for their review, but while the vision and strategy that's driving this whole thing is being reviewed, we might want to speak to that, because that's where all the money comes from. Kia ora.
All right. With that, thank you very much, councillors. I appreciate your engagement on this, and we look forward to report coming to council next Tuesday. Thanks, everyone. So we'll, did we open with a karakia this morning? We did. Would somebody like to close us with a, I'm looking at Molly or Chris or Neville. Oh, Jordan. Somebody want to close this with a karakia? Neville's going to. Got a Neville.
Ka whai te whakamutunga o tō tātou hui e nai nei no reira ki ingoa tātou. Unuhia mai I tūru tapu ni. Kia wātea kia māma te tinana te ngākau wairu I tara takatū. Koia rā e rongo e whakairea ake ki runga. Kia no reira tuta kōrero I tēnei wā no reira koutou te. Kia tīna, haumi e hui e tai.
Tai ki ai. Thank you, everyone.